everybody. Thanks so much for joining. I see folks are still signing in. We're going to get started in just a second. Apologies for the slower start this afternoon. Welcome. Thanks for being here today. And we're going to get started because this is such an exciting topic and there's a lot to cover today. And we have such amazing panelists that I want to make sure we dive in as quickly as possible. Today is the IIP's monthly webinar, and it's Ethical AI for Prosecutors, Exploring Responsible Use of AI in Prosecution. I'm Rachel Marshall, the Executive Director of the IIP, and as many of you know, we host these monthly webinars to provide education, strategies, and insights for prosecutors and other key criminal justice stakeholders to improve their approaches to public safety. The IIP provides a national platform to bring together prosecutors, policy experts, and the communities they serve to promote data-driven strategies, cutting-edge scholarship, and innovative thinking. The IIP champions criminal justice reform policies that advance community-centered standards of safety, fairness, and dignity. Today's topic is one that I really think we can't escape because it's everywhere right now, which is all about AI, which has really come to define and impact every part of our lives. And that is true for prosecutors. But we also know that prosecutors, like many other criminal justice stakeholders, can sometimes be a little slow to catch on to some of the latest technological trends. So today's webinar will explore how prosecutors can make better use of AI, as well as some of the ethical considerations they need to keep in mind when utilizing AI in their work. We'll be exploring what responsibilities prosecutors have in creating policies and practices to guide attorneys in ethical use of AI. We'll talk about confidentiality concerns, and we'll also talk about how AI presents opportunities to identify and rectify longstanding disparities in the criminal justice system. I'm really excited about our panelists today. We have 4 heavy hitters who each bring very different perspectives and experiences on AI and prosecution. For the sake of time, I will very briefly introduce them, but I'm going to drop in the chat right now a link to their full bios so that you can read them, and they're very interesting bios, so I encourage you to check them out. But briefly, I will introduce them. First, I'll start with Steve Mulroy, who's the District Attorney for Shelby County, Tennessee, or Memphis. He was elected DA in August 2022 and oversees a staff of more than 200 people. He's also a law professor at the University of Memphis, where for over 20 years, he has taught and published in the areas of criminal law, criminal procedure, constitutional law, and civil rights, all of which are, of course, relevant for today's topic. He's been a legal commentator on many national news sources and has testified before Congress and the U.S. Civil Rights Commission. So welcome, D.A. Mulroy. We're excited to have you.
Happy to be here.
Next, I'm delighted to introduce Carlos Martinez, who's the elected public defender in the 11th Judicial Circuit, Florida, which includes Miami, Florida, where he oversees a staff of over 400 people. He was elected public defender in 2008, has been reelected 4 times since then without any opposition, and he has been the first Cuban-American public defender and the only elected Hispanic public defender in the whole United States. His office has pioneered the use of AI for indigent defense, which we'll be talking about more in just a few minutes. Next, someone who needs no introduction, Barry Scheck is the co-founder of the Innocence Project, is known for his landmark litigation that has set standards for forensic applications of DNA technology. Since 1988, his and Peter Neufeld's work in this area has shaped the course of case law across the country, led to many influential studies, as well as important state and federal legislation. He has represented, and his work has exonerated too many people to name right here. Welcome, Barry. We're so delighted to have you. And finally, I am delighted to welcome Allison Pierre, who's the founder and CEO of Innovative Prosecution Consulting. She's a former prosecutor and commercial litigator who believes data, technology, and AI have the power to reshape how the public sector works. Through IPC, Allison helps agencies design and implement AI and data programs that improve daily operations while building evidence-based, collaborative, and transparent cultures. Welcome, Allison, and welcome to all of our panelists. We're thrilled to have you here. And again, I encourage you to check out their full bios in the chat. I want us to dive in. We have a lot to cover in this topic, and we'll get through as much as we can. So I apologize in advance if I jump in to move the conversation along. I want to note to all of our attendees, we will be saving time at the end for Q&A. You can start to put it in the chat in the Q&A box throughout this conversation, and we'll go through the questions and save them at the end. But I want to start. Let me start with you, D.A. Mulroy, and then I'll turn to you, PD Martinez, as well. We've been talking already about how AI is everywhere these days. Everyone has their favorite, chatbot, and people are really relying on it in new ways. And even though the legal profession hasn't always been a leader in utilizing technology quickly, I'm hoping that you can each talk about how it's impacted the work in your office and how you've seen any benefits to the use of AI within your office and where you see it going over the next few years.
Right. Well, first of all, thank you. I'm very appreciative to IAP for the opportunity to speak. We are starting the use of AI, and we've made some significant inroads. And the main motivation is simply, large urban jurisdictions, the volume of the caseload is just so crushing that we have to have AI to help us keep up. And because we're not going to get the additions in staff that we sometimes request from the people who fund us. So, obviously, when it comes to actual legal research and writing, both Westlaw and Lexis have their AI tools, so we have co-counsel and protege on Westlaw and Lexis, and that helps. But what we're wanting to do is to move to a situation in which we can take a case file, we can take a state report, and put it into an AI agent and have it automatically spit out a summary, a timeline, suggestions for key, witnesses, and actually generate the subpoenas, and eventually maybe actually even send them out. Not to replace any of our staff, but as an assistant at the side of the staff, everything having to be checked over by a human being, but nonetheless, really making that productivity go through the roof. What it would take ordinarily someone to do, in an entire morning, it could be done in 15 minutes. And so that's what we've done. And I can talk later on. The other thing that we've done is helped out, developed a custom-made system for analyzing jail calls. And we're also using our AI tools to analyze the thousands of hours of body cam video and dash cam video that we have to process every year.
Thank you. And a little bit later, I want to get into sort of what gets disclosed when you're using AI in those ways. But first, I want to turn to you, PD Martinez, to sort of talk about your use of AI in your office and where you see it headed.
Sure. So we're going into our third year of using particularly the generative AI tools. For example, the main one that we use is Thomson Reuters Co-Counsel. And that has changed dramatically from when we signed our first contract to the product that exists right now. So I have all my attorneys are utilizing it. They all have licenses. And with that license comes one license per attorney for a support staff person. I don't have that much support staff. So the main thing that co-counsel does for us is actually provide my attorney something they'd never had, which is a paralegal. The other individuals in my office who have co-counsel are the mitigation specialists. And now they utilize co-counsel to analyze copious, jail records, prison records, medical records, psychological records, school records, military records. And then from that, develop timelines and also develop, kind of an outline for the attorney to utilize in the attorney setting up the case for mitigation, not just a trial, but trying to get a better plea offer or trying to get a client placement before the fact. So those are the two major groups that have it in my office, but it does a lot of things. We've used it to draft deposition questions, draft letters, cross-examination, opening argument outline, closing argument outline, assessing arrest affidavits, and developing a timeline. So there's a tremendous amount of use. And I'm going to touch on something that I know it's critical for attorneys. As attorneys, we are expected to abide by the professional responsibility rules. And one of the main ones is confidentiality. The reason that we use co-counsel and that's our primary product, is because that is a closed system. And that is a system that was developed for attorneys, by attorneys, and it's the AI that they have. It is not learning from the information you put in, and the information that you put in is not being shared by anyone, outside. So those have the best, for us, those have the best protections in terms of legal protections.
I did see a comment saying someone lost audio. I don't know if it's just them. If anyone else has that issue, please put it in the Q&A, and you can put your questions in the Q&A. I want to turn to you, Barry, to follow up on kind of what was just said by both DA and PD, because I think that a lot of what's been said has been a little bit scary to some people maybe on this call, right? It's about increasing efficiency. So what does that mean for the legal system overall? You teach a course on AI and criminal law at NYU Law School. And how do you see AI reshaping the work? We've heard about how it makes things more efficient on both the public defender and district attorney side, but what concerns do you have about that? Where do you see it heading? Barry, sorry, you're on mute.
My apologies. If you could drop into the chat if you don't have it, or we can send it to people, actually the syllabus to the course, where I was very grateful that you participated, and Carlos did as well, because we did try to look at, the entire system, and try to align the artificial intelligence tools with social and democratic values, which was the purpose of Alondra Nelson and the Biden administration, because they laid out a blueprint for how to do that. And unfortunately, that was thrown out the day the Trump administration took office. And during the course of this, one book I would recommend right away, anybody who reads it will understand that artificial intelligence is based on getting digital information. And Andrew Ferguson has just written a book called Your Data Will Be Used Against You, Policing in the Age of Self-Surveillance. And he's been a great scholar in this area. This book is really kind of mind-blowing, and it just came out in March. And it hits all the issues that I think every district attorney wants to think about. But one of the things that arose immediately in our course is, first, the dangers of hallucination. The large language models that are being used for legal research are subject to a study by 5 Stanford computer scientists that was published in 2025, and found rates of hallucination between 17 and 33%, which is kind of mind-blowing. And I didn't realize this till we did our second course on ethics. Then we became involved in helping the public defenders in Nevada County, California, because the district attorney's office in that county had filed a completely hallucinated citation brief in one case and denied at first that it came from the use of a large language model, and then a number of other filings that had terrible factual inaccuracies. And when you look at the Stanford study, they define hallucination as not just the totally fabricated case, but you put a prompt into the large language model, it gives you back erroneous information, or it gives you misgrounded information. It's not really asking your question. We did get the California Supreme Court to actually order an investigation of the Nevada County office with experts to see, basically do a root cause analysis. What went wrong and how can it be fixed? And just very briefly, this is going on all across the country. It's a major issue to be faced. One of the things that Carlos just mentioned is that in his office, they say that they have what's known as a closed instance, that when you do your legal research, it's not escaping when these large language models try to get anything outside. That is a major issue. Ordinarily, only large law firms have actually been able to buy ways of doing this. And I must tell you, as I've told Carlos, a lot of us are highly skeptical that even the closed instances are working. And these claims that they are encrypting everything from transmission and back are working. But on the positive side, the very positive side, there are advantages to using public-facing databases. I know a lot of offices have done it. You might want to look at District Attorney Harold Pryor Jr. in Broward County has a very nice public-facing dashboards. People are trained on that. And frankly, more importantly for all of us, in California, we have an extraordinary program of what we call the Community Law Enforcement Accountability Network. We've used large language models to get all the adjudicated acts of misconduct of both police officers and correction officers in the state of California into a public-facing database that's hosted by the Los Angeles Times, San Francisco Chronicle, Cal Matters. Its database is getting better and better every day because when you go there, you can get all kinds of information, but we had to develop tools to do it. So I think public-facing databases are an enormous advantage, and you could only do this at scale with AI tools.
Thanks so much, Barry. And Allison, I want to bring you in. Barry covered a lot just there, and we want to dive into some of it in more depth. But I first want to sort of get your initial reaction because you work with offices in implementing AI and tools. And how do you assess if an office is ready, and what do you suggest are some initial steps, and particularly keeping in mind some of the concerns Barry raised about closed universes and thinking about the problems of hallucinations? What do you think an office needs to do to make sure that they are ready to use AI and that they're set up to do it in a responsible way?
I think the first step is to actually really take a step back and ask yourself, if you're an elected in an office, do you have data infrastructure? Do you have a way to collect data, store it, share it? And do you have the internal and external team to help you manage the data? Before you even get to AI, you have to start with data first. Then you can think about what's the particular problem you want to solve with AI. And then you can create a small pilot that addresses that problem. And I'll give you an example. Let's say the problem is you want to use AI to review digital evidence, which could be evidence like police body-worn camera footage and dash cam footage. Then start there small with a pilot in the office, and then think about how you're going to scale it. But I would suggest doing it in a way where you're not just hiring a vendor to come in. First, have a strategy and start with 1, assessment, 2, come up with a pilot, and then 3, you can scale your pilot. And I'll pause there, but one more thing. The major thing that I would ask everyone to do is first take a step and think, what is the need of your office? What is the major problem you want to solve? Because you're going to need that for buy-in later on. Don't just hire any kind of AI vendor. Yeah. Start with what particular urgent issue you need to address right away that you can't do in another way.
Thanks so much. Dean Mulroy, I want to ask you, you talked a little bit about your office's use of AI, and I would love you to talk a little bit more about that partnership that you formed, but also asking about, you've been careful to make sure that, as you said, there are limits to what the AI can do and that it's not going to make charging decisions. There's always going to be human review, you mentioned. How do you build that principle into daily practice? So when you say that there's always going to be that human oversight, how do you make sure that that's really happening in a rigorous way, especially as folks get more and more accustomed to really relying on it for summaries, for review of documents?
Right. Well, so the partnership that we had some number of months ago, which I'm very pleased about, is a local company called Lokion. That was a data company, and just really as a matter of civic service, had volunteered to work with us, no charge, to develop AI tools that would be a great assistance to us. And the project we chose was one that would help us to analyze jail calls, because that's also a very large volume of data that we have to review. And so they worked for a number of months with our prosecutors, refining the tool, helping to figure out what would be the most useful, what are the kinds of things that we tend to look for when we're monitoring jail calls, and refining that tool, like I said. And now we have something that's pretty robust. And what it can do is it can analyze hundreds of hours of jail calls from all the defendants involved in a particular case. And you can put inquiries, ask for, indications of a particular item, like, are there any indications that would lead to a defense of diminished capacity, for example? And it will identify things, and it will put summaries, text summaries of all the different jail calls along with the audio files, and then you can click and go right to that part of the file. This is a very useful thing for internal documents. We are not using it in anything that we are sending out, not anything that we're filing with the court, not anything that we're sending in discovery. This is just to save us time. The discovery practices have not changed. We still upload everything and make everything available to the defense. This is just to save us time in, preparing or investigating and getting ready for trial. So there's nothing about that system that even purports to make a recommendation about charging decisions or bail decisions or anything of that nature. So that's one safeguard on what you're talking about, Rachel. And then also, I'm not going to require those prosecutors to manually listen to hundreds of hours of jail calls. I'm going to allow them to rely on the use of AI to select out the 90% of stuff that is not pertinent. But they are required to actually listen themselves and read the summaries themselves for everything that they do consider to be pertinent and that is going to inform their decision making. That they have to review themselves. So really what the AI is just doing is separating wheat from chaff, getting rid of the chaff, and then allowing the prosecutors to focus more on the wheat. And so as a result, that system doesn't really create the same kinds of challenges you're talking about. Now, in other areas, we're basically doing the same thing where we're using it to review video cam and body cam. Again, it's separating wheat from chaff. We still have to look at the pertinent stuff ourselves and make a decision based on that. And then, we have a policy that says that if we are using anything that we're going to be sending out externally to the defense counsel or to a court, everything has to be checked by a human being in our office for material accuracy.
And just one quick follow-up on that last piece. I think that was a very helpful explanation, but how do you ensure that oversight is meaningful at that back end?
Well, I mean, no system is perfect, but like any other requirement in the office, we have supervisors who supervise the line staff, and we check the work, and if there are ever any complaints, we circle back. I mean, nothing's 100% foolproof, but that's true about anything. I mean, how do we assure that there aren't Brady violations? Well, we train them, we remind them, we have supervisors looking over them, and then if there are individual complaints, we investigate the complaints and take corrective action where necessary. In my view, it's not really any different.
Barry, I'd love to get your response.
I just have a question for Steve. So Steve, the company that you're using to monitor the prisoner calls to others on the outside, obviously not attorney-client calls,
Right.
That has happened with, is it either GTL or Securus?
The company, no, it is neither of those.
Yeah. And so those are actually oligopolies in this field. And they've been found by some great work by a woman named Cynthia Conti Cook in New York City. It did an analysis of all the patents that they have, and they're actually selling the data because, people will call friends and family, and they actually, what Cynthia found is that, they have location data on these calls. They have, they're able to hook it up to even license plate readers and, do basically a sociogram of who the prisoner is calling. And then they can sell a lot of this data to data brokers.
That's interesting. I didn't know about that. It's neither one of the companies.
That's why I'm telling you.
Yeah. So I'll be on the lookout for those two companies. The company that provides the call services to the sheriff's department, which runs the jail, is called ViaPath.
Mhm.
And we just take the call straight from the sheriff's office because they use ViaPath. And then we use Lokion, a separate company, just to take the calls that we've already been provided from the sheriff and analyze them internally. And as far as I know, well, I know for sure that Lokion isn't doing this. And as far as I know, ViaPath is not doing the extra data sharing or extra usage of the data that you were describing. But I think it's important for us to be mindful of that.
And then certainly there's other prosecutors here with potentially other systems. So thank you for mentioning that, Barry, and thank you for that explanation, DA. PD Martinez, I kind of wanted to get your take on all of this from the defense side, but also as someone who's a real leader when it comes to AI. How did you approach it? How did you navigate some of the concerns that maybe Barry raised, maybe others in your office raised to achieve office buy-in? And how do you also be responsive to evolving needs or evolving concerns that may emerge as AI develops seemingly daily?
Yeah, so what we did initially in our office, we started out with machine learning, which is a type of AI, which is now what we're talking about, which is generative AI. So the initial machine learning that we engaged actually made it easier for the attorneys, because what we were doing is taking everything that we got through e-service, and when it came in, it was automatically being directed to our case management system without having a human taking every single email or every single e-service and moving it from one place to the other. So of course, when people hear that, they're like, oh my God, you eliminated positions. And the answer is yes, I eliminated positions. The reason I eliminated positions is I couldn't hire anyone because of the poverty wages that I had. During COVID, couldn't hire anybody. So we worked with a company and they ended up developing that tool for us. And that tool is saving us a lot of time, a lot of money. The error rate is less than 1%. And we found that by doing some testing of just going in and seeing, let's see what it transferred. And we know what was transferred by a human and what was transferred by the AI. So that's one big part. But I think the part you're asking me about is the attorneys, because that one's administrator type stuff. But the attorneys, for them, they have found it extremely useful, and particularly now, again, because we've been with CoCounsel for so long, we were even before CoCounsel bought out the product. We were with the other company before, and then they bought it. But because we've been with it so long, we've seen all the changes. The latest change, we can actually upload what the prosecutor briefs, motions, or whatever. We can load ours, and we can look for errors. We can look for fabricated facts. We can look for miscited facts. We can look for citations that don't exist, but we can also look for citations where the holding is not what the prosecutor is saying. For example, so there's a tool, I call it the BS tool. They call it litigation. They call it litigation examiner, but it's really useful. And then they just rolled another one out that is for the judicial angle. So it takes whatever you filed, whatever the prosecutor filed, and it examines it from a judicial point of view, what the factual gaps are, what the legal misstatements are, and all sorts of things. So the attorneys, most were reluctant at the beginning. They're like, I don't want to use AI. The AI companies utilize too much energy. They utilize too much water, all the stuff that young people know about. So they had all those complaints. But once they started using it, and once they started, what really motivated them, and I know Steve probably is interested in this, but what motivated my attorneys is catching the prosecutors messing up. So they load up their stuff, and all of a sudden, oh, this is BS. And also comparing, we can put in multiple documents. You can set up a database and have the system examine the whole thing. The coolest thing about the tool that examines the litigation documents, you don't have to prompt it. All you have to do is drag and drop your documents, and it generates this entire analysis for the things you should be looking at, the things where you have messed up, the things where you need to get clarification, and all sorts of stuff. So now the lawyers really see the benefit because the lawyers are analyzing their own work. I know you did not ask me this, but because time is short, I want to make sure I don't forget. One of the key issues is what training are you doing? And who's providing the training. So what we do is we have the Thomson Reuters company. They do regular training for our staff. And on top of that, we have trainers here. And they meet with their folks on a regular basis. And they actually work through some of the AI issues on how to prompt it, what kinds of things to look for, and all that other stuff. The most interesting thing that we found is that I actually authorized last week prohibiting some of my staff that were recently hired from using AI for 6 months. And we did that with the LCSWs, licensed clinical social workers, that are mitigation specialists. And the reason we did that is we just hired them. We are training them on what the defense function is, what all the documents are, how it fits in, how the defense works, and all those things. And part of the training was, here's AI and here's how we use it to generate, a draft report for the attorney to review. Unfortunately, when our trainer started asking them questions, because they're reviewing every single document with these folks, and they would ask them questions, their knowledge of what was generated was so shallow that the trainer came to me and said, this is what I want to do. Are you okay with doing it? Because you're so big on AI. And I'm like, absolutely. They need to learn the basics. So that way, later on, they can examine what's wrong with what the AI generated. But if all you're doing at the beginning is just, oh, I'm going to save time, that's not good because that is really problematic because they're not learning the basics. They're not learning the law. They're just asking Westlaw, the co-counsel, asking co-counsel, what's the law on this? And then all of a sudden it spits certain things, but it may not necessarily be from a defense perspective. So we've had to pull back. So be careful on how you roll it out. It's very different when we rolled it out with attorneys because attorneys at least have the basics on how to do legal research themselves, how to evaluate documents and all those things. So when they're using, co-counsel, or they're using Westlaw deep research, they have the basics and they have a lot of the critical thinking skills already as it relates to our work. That was not present yet with a social worker.
Thank you. And Allison, I'm going to turn to you in just a second. I think you touched upon some very, very critical points there, both about a lot of us and probably a lot of us on this call have been lawyers trained before AI had taken off. So we're using AI to adjust to the skills we already have. What do we do with the new generation that's coming in without those skills? And does it potentially weaken the impact of a defense lawyer or a prosecutor in court if they haven't gone through the case in the same way because they've relied heavily on AI? Are they less effective somehow in their representation? That's just a question I'll let percolate. But Allison, let me turn to you, and then I want us to dive into some of these ethical considerations a little bit more.
Absolutely. I think what's so amazing about these two offices, DA Mulroy and PD Martinez, is you all are frontier. You're light years ahead, arguably, than the 2,400 other offices plus around the country. And I think the reason why you all got buy-in is because it started from the top. The change management, the adoption, it came because the mission was to adopt this. And I think that's something to think about. If you're listening and you don't have that scenario and you're interested in bringing AI into an office, think about how you can get buy-in. Do you need incentives in your office? Do you need to be thinking about how attorneys are evaluated, because that's how attorneys are now being evaluated in law firms. And a lot of public defenders and prosecutors go to law firms now. So think about that. And in terms of one more point, then I'll go right back to you, Rachel. I know we talked about errors, and think also about how you can really work with your vendors and make this a safe program for you.
Thank you. I think that's a really important point to transition us into thinking about some of the ethical considerations around, some of which, Barry, you've already touched upon, and everyone touched upon a little bit. But Barry, I want to turn to you. You mentioned this in your opening remarks, but I wanted to get a little bit deeper into it. There was a troubling case, for those who don't know, out of Nevada County, California. You mentioned it, which is kind of the worst case scenario, I think many of us would say, and certainly what DA Mulroy was talking about guarding against. Which is the use of AI to just completely hallucinate and fabricate cases that were cited in briefs. And so I want you to sort of dive a little deeper, Barry, into sort of how you think the problem of hallucinations should be addressed by prosecutors, and how you think it fits into some of the larger concerns around the use of AI in the criminal legal system.
Well, it's not just prosecutors. I mean, I'm very distrustful of these vendors. I mean, it's not, it's people that you realize a lot of law schools just won't let the law students use these large language models to do legal research. They didn't want to because they knew there were problems. And, some of the answers I got from nobody's refuted the data that I have seen yet from the Stanford computer scientists. And these were real studies. So the burden is really on them before they have lots of law firms, district attorney's office, prosecutors' offices starting to buy in. Now, Carlos is in a good position because he, and I know somebody out in California, Mike Szymanski, were, pilot officers, right? So they're trying to do everything they can to help them. I would want to point out one thing that was just said, and I think Carlos, you agreed when we talked about this in the course, and that is, it's not so much that people are making errors, but in terms of using the tools when you're trying to put the humans in the loop, so to speak, because of the actual AI. It's because they don't know the subject matter well enough. So I would advise everybody to take a look at a wonderful blog, a Substack, by Patrick Barone, Barone, AI on Trial. He's written a number of articles for The Champion, the NACDO magazine, but it's a great blog. And what he advises, and I think anybody that has studied this carefully, because there's lots of ethical issues. There's the duty of competencies. There's the duty of supervisors to make sure that everyone in the office conforms their conduct to the rules of professional responsibility. But you have to know the subject matter here. If you don't know the subject matter, I absolutely guarantee you these tools are going to give you, misgrounded responses, erroneous responses, and Lord save us, completely hallucinated responses, which you should never miss when you're putting it in as a citation. The other thing that I would want to mention before you turn to whatever the questions are in the chat, that there's a few other things that I think prosecutors and police departments should be really looking at. There's the whole issue of Axon and others offering computer-assisted police reports, right? In other words, you use the body cam footage, and actually, if you really do a deep dive on it, you'll see also the police radio communications to help a police officer write a police report quickly, because, they can immediately take the audio to text and make a police report. California, an amendment was a statute was passed, said if you're going to even go down that road, you have to have an audit trail. In other words, the vendor must give you an audit trail of exactly how it went. And I would point out to everybody right away, these are not like, we were all trained, right? Officer fills out a police report. gets on the witness stand, can't remember exactly what was going on, so says, I want to look at my report. Defense lawyers are trained to say, let the record reflect he or she is refreshing recollection from looking at the police report. Then if they still can't remember, because often these are cases from a long time ago, then you eventually have to get the prosecutor will have to get to admit it as past recollection recorded, whereby you say at the time that you filled this out, you remembered it clearly and you're under a legal obligation to do so. Yes. So the report, as Andrew Ferguson points out in a very good law review article on this, the report is the officer's recollection, right, of what happened. And it's really a fundamental of how cases are made. It's a series of police reports, often, murder books, DD5s, we call them in New York, or 302s for the FBI. If that's not the officer's recollection, right, that creates serious problems. So that's why you have to have the audit trail. I would point one other thing out, which I think is really important. I think that the profession missed the boat when we did not insist with body cam footage, that first thing that should happen is that the police officer ought to be asked a cognitively clear question, tell me everything you remember. And then the officer writes down everything he or she remembers. Then and only then should they look at the body cam footage. And then if they see anything that they think was wrong, or they see anything that triggers some other recollection, then they come up with a full police report, right? That's the way human memory works. We know this from all the work we've done on eyewitness identification, right? This is a big problem. So in forensics, when we're talking about best practices, for example, for fingerprints, first the analyst is supposed to look at the latent print, identify everything that will be informative, anything that could be a red flag because the print went down on some surface and it was an artifact. Then you look at the reference prints, and then if the analyst has anything to add, you create the final report. This is called sequential unmasking. It is an essential tool when you're trying to avoid cognitive bias. And this should be put into the way that Axon and all these other vendors are coming up with the writing of police reports. And I can't do that just by pointing it out with all the experts in this field. It took long enough to get eyewitness identification best practices, authored by reports and through legislation. But district attorneys had to be doing this, because if we don't do this now, right, it's going to screw up everything. And it is also for the protection of officers and your case, because the body cam footage is only showing one point of view as to what happened. And there's things that, the officer may remember and have done that is not within the point of view of the body cam footage. And that's very important. And there will be other officers coming to the scene, and they'll have their own body cam footage. And then you're going to wind up with the surveillance footage, that from people on the street, but also from surveillance cameras on every street corner. So this is important to do.
Thank you, Barry. Steve, I saw that you had or DMO, right? I saw you had a question or comment.
You're muted, Steve.
I just wanted to make sure, I think Barry's made a lot of useful points. And I just wanted to mention that, we have an AI policy that's written in our office, and it specifically says that if law enforcement uses AI in any way in preparing any of the documents that they send over to us, they have to sign something that discloses that and affirms that they have reviewed it and that they're vouching for the accuracy of all material information. And I think that's an important check.
Yeah, thank you for that. And that leads me into my next question, which is for you, PD Martinez. From the defense side, when prosecutors, or I guess police as well, as DMO just mentioned, are using AI as a tool to surface evidence or to create evidence, What does that mean for your ability to prepare a defense? How does it impact a defense case? And what would you ask prosecutors, if anything, to do differently or to think about when using AI in their offices?
So I think the biggest area for that right now down here is facial recognition technology. And that's been a very big issue down here. And we have been forcing the prosecutors to reveal a lot more information. And thankfully, I think it was a Washington Post reporter who did a really good article on facial recognition technology.
Douglas McMillan.
Exactly. And so he contacted me when I knew very little about facial recognition technology. So what did I do? I asked co-counsel, tell me everything I need to know about facial recognition technology, including what are the legal issues presented, admission issues, issues of how they maintain information. It gave me a document that was either 6 or 7 pages long. I read that thing. It was thick, but I read it. I felt so comfortable with it that I called the deputy chief of police of the agency that's using it down here, and I asked them all the questions. And his response to me is, who did you hire as your expert to come up with these questions? And I ended up telling him I didn't hire an expert. I used AI to tell me these things. But we have actually, as a result of that, not just the report that came out in the Washington Post, but the prosecutor's office, there were a lot of line attorneys who had no idea that it had been used on their cases because the officers were not revealing it in the arrest affidavit, that the way they had come up with the suspect's photo was by using facial recognition technology and all sorts of things. I think we had several cases dismissed without even having to file any motions, because the back and forth and the discussions, including with the police department, they're like, and frankly, part of it was, which was shocking, that the officer who was presenting the information to the witness was a different officer from the one who did the analysis and who eliminated suspects. Because, they come up with a certain number, depending on how you set up your parameters. They can even come up with 32 different type of suspects based on the information that is fed and all sorts of things. And then there's a human that goes through and eliminates a bunch of them. So when we were finding out what the process was and talking to the prosecutors, some of the prosecutors were really uncomfortable with the way the process had gone through, because there was no independent verification by anyone, no additional witnesses, no video camera anywhere. It was just from what the officer fed the system, what it gave the officer eliminating things. So I don't know to what extent it's using it. It's a good time for me to go back and ask my folks what's happening with this. But we litigated a bunch of these things, and many of the things, surprisingly, pleasantly surprising, was the prosecutors were so uncomfortable. And the prosecutors were demanding the department to identify for them when it was that they had used that. Now, in many of the cases that the Washington Post brought to our attention, that was not the sole evidence whatsoever. There was so many other things. There were fingerprints, DNA, there were all sorts of things. So it was not just some information that an eyewitness said, and then they limited what the query was, or they expanded it beyond what it should be to match a particular result.
I should say that everybody should take a look at a National Academy of Science report about facial recognition technology. They couldn't reach an agreement about exactly how a statute should be formed, but there were best practices put in place. It's very important, and it's not a secret, Douglas Macmillan came to a seminar we put on and led him to a lot of stuff. He did a great job. But the eyewitness identification problem and misidentification happened in a number of cases. So what I would really refer you to, and we can put this in the chat, is probably the most egregious or salient, I should say, misidentification was an individual, Williams, in Detroit. And the ACLU did a very, very good job of litigating that as a civil case. And what was really great about it was Nathan Wexler, the same guy that argued Carpenter in the United States Supreme Court. They have a very, very good settlement agreement. And that is, first of all, everybody agrees you cannot arrest somebody based on facial recognition identifying somebody with whatever percentages they give to that. No, not even the vendors, will even agree to do that. On the other hand, there's a serious question about any person identified by facial recognition. Should they even be put in a lineup or a photo array, right? And if so, before that happens, shouldn't there be some evidentiary showing that there's independent evidence to believe that the individual identified through the facial recognition, there's some evidence to believe that he or she actually committed the crime? And that's part of the settlement in the Williams case in Detroit that we can make available to everybody, and it should be part of a standard now. This is really troubling. One of the things that a federal judge, who I will not name, who I exposed to our curriculum, also pointed out that when people are making a motion, and he was thinking federal court, for a warrant, that there should be in that warrant application exactly what Carlos is talking about, a statement as to whether or not artificial intelligence tools or facial recognition was used, right? And if you don't put that in, then it should be presumptively, a false warrant application. So
Thanks, Barry.
that would be a good thing to do too.
Thanks so much, Barry. Allison, I want to turn to you because we've been talking about a lot of ethical concerns. And one of the things that Barry raised earlier, too, is around the closed universe question and making sure that we're protecting confidentiality, or how we can make sure we're protecting confidentiality. What details need to be kept confidential when prosecutors are using AI as a tool? And how should they make sure that they're protecting that information, or frankly, anyone who's uploading it, and any relation to the criminal justice system? And then my other question for you is, how should offices create policies to ensure that this information is being protected, and to keep apprised of issues like what Barry mentioned around companies selling data when folks might not be aware of it?
In terms of confidentiality, it's really important to protect names of witnesses, victims, eyewitnesses, police officers, addresses. All that is confidential and can't be released to the public. So you have to go back to the kind of vendor that you're going to be contracting with. What I would recommend is everyone take a look at the Council on Criminal Justice's report that came out March 2026, just last month. And they have best practices on, before you hire a vendor, it's a checklist of what you need to make sure you have in terms of safety and guardrails, so that there's no leakage of confidential information. So that's part one. Part two is the internal policies that you should think about. It's so important to have, at the bare minimum, I think, some written internal policies about who should be using AI, for what purpose, and how it should be used. And I wouldn't stop there. I would even suggest having someone in your office who's going to be in charge of working with the AI vendor, who can make sure that you're in compliance with your local jurisdictional rules, your professional responsibility rules. And that role, I don't think, is even in existence in some jurisdictions, but in every office, you do need someone who's going to be watching to make sure that, let's say you work with a vendor, that it's appropriately updated, and not every year, every 3 months, because there's going to be different iterations of the system. Let's say you decide to work with Axon, for instance, and use it to review digital evidence. You're going to make sure that you're working with your Axon vendor and understanding all the changes that have been made, that there's guardrails, and making sure it's customized and closed so that it fits your office's needs. So what I would ask everyone on this call, please take one step back and go through that report from the Council on Criminal Justice, because it's the only one that I know of that's a national best practice guideline that's new. But don't stop there. Think about what you want to do for your office as a customized strategy to bring AI into your office.
Thank you. And I just linked that framework as well, and was hoping we would get into it a little bit more than we may have time to today, but I encourage everyone to look at it. I wanted to ask a little bit about how some of the AI tools can be used to remedy disparities and to promote equity within the system. We've talked a lot about some of the ethical challenges. What are some of the opportunities? How can AI be used to perpetuate, or sorry, not to perpetuate, to correct for wrongful convictions? Or is it going to be used to perpetuate wrongful convictions? Can it be used to address racial disparities? Allison, you look like you want to jump in on that, so I'll let you.
Thank you. I want to tackle that one because racial disparities is something that can come up in charging, plea offer, bail, and sentencing recommendations. And instead of having very complicated data dashboards, you can use an AI tool that can look at reports in your data dashboards and give you summaries. And you can use an AI agent to see if there are racial disparities in those decision-making points, charging, plea, bail, sentencing. So what I would encourage everyone to do is think of it not only for efficiency, but it can be used for reform too. And it should be used for both efficiency, reform, and safety. So think broadly about how you can incorporate it.
Yeah. I would like to follow up with that. The effort that we've just made in California to get all this statute is kind of unique and should probably want to get it in your jurisdiction. I realize it's not a simple matter, but in California, every police officer and every correction officer has a unique identifier. And that's new, right? Because if you start putting up a database of officers that have either adjudicated acts of misconduct, and as you can get now in many states, unsubstantiated acts of misconduct, and I always was puzzled, why are they divided up that way? Adjudicated acts of misconduct, unsubstantiated, and unfounded. Why do the police do that? Well, police department heads of police departments know that investigating themselves, they may not exactly get a completely honest outcome to the investigation. And by having an unsubstantiated category, it serves as an early warning system that they may have a bad cop. But by having the unique identifier now in California, we can track everybody. And in building this database, the biggest problem we had is that, as has been mentioned, I think, by Allison before and others, when you get information from a police department, they don't clean it for personal identifying information, even though that's the law in the state. So the deal we made with all the legacy media is we will do that and set up some very complicated tools to very quickly get a human in the loop so we could really say, oh, this is the officer in this category of officer-involved shootings that was there and actually do it with a human in the loop. Because it takes other ways, other programming to effectively get a human in the loop when you're dealing with these gigantic data sets. But we're going to try to go across the country now in each jurisdiction and try to set up these public-facing police misconduct databases. And that's essential. I mean, for those of you who are not necessarily aware, and I wasn't, it's the states that have the strongest police unions that have the worst laws. So, of course, I have a bar card in California and New York, and those were the two worst, right? In the George Floyd moment, now lots of states have transparency. And interestingly, a lot of what are called red states, Florida being chief among them, have outstanding transparency laws and have had them for years and have done more decertification of police officers than other states, right? So it's an interesting process. But now to put up these public-facing databases, I cannot begin to tell you. You go into Oakland, California, and we put up a portal of everything that we got in this monumental effort to get the police misconduct database out, and everybody in that community wants to know who those officers were, what the situations were, et cetera. And that'll be true all across this country. And this is fundamental to criminal justice, I personally believe, from all the studies that really started with the Invisible Institute in Chicago and lots of amazing studies of crews of police officers, because they got the best data because of a case called Calvin versus the city of Chicago. This is extraordinarily important. We have not, when a police officer lies, cheats, uses excessive force, does something that is outside the lines, that the district attorneys have to know about it, the police chiefs have to know about it, and the public has to know about it. My own personal view is that investigative journalists have to know about it, because that has been the only thing that's ever moved the needle on police accountability in this country. Good investigative journalism and a scandal. That's the only time in my experience that you have real accountability and real commissions looking at what's wrong. It's fundamental.
Thank you, Barry. DMO Roy, have you thought about, has your office thought about looking at data or using AI tools to audit charging decisions, to address disparities? And do you think that there are opportunities for DA's offices or prosecutors' offices to do such?
So the answer is no, I hadn't until you asked me that question earlier, and I've been hearing the discussion today. So now I'm interested in doing it. Well, what we had done is we had old-fashioned human beings doing some of this work first. We had the Vera Institute come in and kind of embed with us for a long period of time. We used the Justice Innovation Labs, JIL, to help us sort through data, and took a hard look at our racial disparities and what we can do about them. Had not had the opportunity to use AI tools to do that, but to the extent that you all were talking about using AI as a tool not only for efficiency but also reform, I'm very interested in learning about that. One of the frustrations I have with respect to my efforts on curbing racial disparities in the system since I've taken office is that the Vera Institute was able to point out a few offenses here and there where our office actually exacerbated the racial disparities. And so we were able to focus on those. But the vast majority of the time, the racial disparities are coming in from law enforcement. And I don't really have direct authority over law enforcement. I have tried to share with the law enforcement agencies the data out there that shows that non-public safety related traffic stops, you get a really low hit rate. You find drugs or guns maybe in 2% of the cases, but there's an opportunity cost there, and there are much better ways that they could be using their time, because those equipment-oriented and expired driver's license, those things that are correlated with poverty, if you focus on those and you focus on them in minority areas, because minority areas are supposedly the high crime areas, what you're really doing is you're exacerbating the racial disparities. But, law enforcement are big believers in those, and they continue to use them. So, my own opinion is that the largest driver of racial disparities is coming from agencies that I don't really have any direct control over. But if there's ability to use AI to help figure out what the DA's office can be doing or what the courts can be doing, I'm all for it.
Thank you, DA. And let me bring you in, PD Martinez, to see your response to that and sort of if your thoughts on how AI can be used by prosecutors or any other players in the system to address disparities. And I also wanted to follow up on what Allison mentioned. She mentioned the Council on Criminal Justice's new framework, which I linked to in the chat, about AI. And one of its recommendations was formal reassessment annually, and it talks about the pattern of potentially degrading AI tools over time. And how do you stay on top? And this can really be a question for anyone as well. How do you stay on top of whether an AI tool is really functioning the way it did when you adopted it? And we know that AI is moving so fast. You mentioned just being reflective about when you're even allowing folks in your office to use AI, but how do you know that the tools themselves are as reliable as they may have been before? It's a big question. I'm sorry.
That's several questions. Compound questions, counsel.
We're turning to Q&A in a minute, so I'm trying to sneak in a bunch of questions at the very end before we turn to Q&A. Sorry about
that. Not a problem. So, I mean, there's a lot to wrap around that. I think the most important part, something that Steve mentioned, which was the issue on how they've looked within their office, and they've looked at the ones that they can control and how they manage. So, for example, diversion decisions, decisions on charging, on reduction of charges, and all those things. I think it would be useful for a prosecutor's office to actually do that, to address some of the racial disparity issues. But Steve also mentioned one of the key things. In Miami-Dade County, typically that is driven by law enforcement, who they're arresting, where they're choosing to police, what they're choosing to arrest people for, or give people a citation for them not to be arrested, and those kinds of things. What I've been most interested in, and I've been in excellent discussions with Thomson Reuters, is in the arena of mental health. And what I mean by that is we have thousands of people in Miami-Dade County every year who go through the involuntary commitment process. That's a civil process. And at the same time, we have thousands of clients who have mental health issues that they've had for a very long time, and they keep getting arrested instead of being put through the civil process, or instead of having some other things done. We also have had some clients who actually got killed by the police when they were having a mental health crisis. So what I like about the tools that are going to be available, they have, I forget what the name of it, they will kill me because I don't remember, but they have a tool that does bulk analysis. And the bulk analysis does, I think, about 10,000 documents that you can examine. And what we're working with them on is actually examining arrest affidavits, transcripts of 911 calls, transcripts of body-worn camera, records of excessive use of force by the police on cases where we know the person has a mental health issue. And what we're working on is kind of doing the bulk analysis to try to figure out what are the best practices that we could be putting in place. Because obviously some of the times, a huge number of the times, it's actually worked to keep the person out of jail. But in other times it hasn't. And in other times, sometimes we've had situations where an officer was injured because they responded to a scene where somebody was having a crisis. So what I'm trying to look at and what I'm focused on in terms of where to go next is looking at all the data that we have available internally for my cases, and trying to figure out what are some of the things that we could be doing better in terms of trying to earlier identify a client that should be diverted and bring that issue up to the prosecutor or bring it up to the court to try to figure out what else can we do with these things. And also identify training issues, internal training issues, prosecutor training issues, judicial training issues, because sometimes we have judges that say some of the craziest things and you're like, you're on the record. And so my focus, even though I mentioned the racial disparity piece, because it's so law enforcement driven, I don't think you can have that much of an impact on that as far as using an AI tool. But for mental health for behavioral health issues, I think you can.
Thank you. And I just want to say we have so many amazing questions and obviously a lot more to talk about, but we're going to try to use the next 15 minutes to get through as many of them as possible. And I just wanted to follow up, since there has been some conversation about policing, that John Jay's Future of Public Safety Initiative is part of the AI and Justice Consortium and did a series of webinars, including one on policing and AI. We'll link to that with the materials. Future of Public Safety Initiative is also a co-sponsor of today's event. So I just wanted to mention that they've done some great work on some of the areas we've been talking about. I know Dia Mulroy has to hop off in a couple of minutes, so I wanted to turn to some of the questions in the chat that are directed to you first, and we do have some fantastic questions for everybody. Dia Mulroy, what items are you uploading into CoCounsel, and how are you ensuring CGIS compliance?
Well, so both CoCounsel and the Lexis Analog Protege are, in fact, CGIS compliant. We've checked with the vendors and double checked, and it's a closed system, like we were talking about before. The information is not shared; it's kept confidential. So, there's no concern there. The same is true with Lokion. I know there was a question about the spelling of the company. I put that in the chat. The same is true with them. Now, in terms of what information we're uploading, early on, what we were just doing was, using it for legal research. But what we are trying to move towards is a system, like I said before, where the entire case file can be uploaded with the request that it generate witness lists, timeline, summary, analysis of weaknesses in the case, as well as a list of people that need to be subpoenaed. And although we don't currently, the next step for us, what we want to do and haven't gotten yet, is being able to link it with an ability to actually generate the subpoenas themselves.
And are you aware of other tools? Someone asked just now that CoCounsel has been mentioned, but are there other options out there that are CGIS compliant? Allison, I see you nodding, so I don't know if you want to.
Axon, yeah, we're using it. We're using the
We are too.
AI tool and Axon to review the video.
A good amount of prosecutors are using Axon. A lot of police departments use Axon, as well as there's other vendors. And I would encourage everyone to research what they think would be the best vendor for them. If you go into Claude and ask what is the top 10 digital evidence review companies around the country, do your research and figure out which one fits your needs. And don't just jump to a particular contract. Really do some research first.
And use AI to do it.
Exactly.
Well,
that is
get an audit window.
District Attorney Mulroy. Yes.
Get an audit window and with Axon. I mean, if you ask for it, I think they'll do it.
Thank you for those responses. With growing fears of an AI bubble, this question asks, what plans are in place if support for different generative AI tools disappears? I don't know if anyone wants to take that one.
Wow. I don't know. You think that the support for using generative AI may disappear? Maybe. I hadn't really thought about that. What we're really very basic with this. We have a large volume of video and audio and text material, and we want to, for internal purposes, very quickly analyze it and separate wheat from chaff. Even if there is an AI bubble, even if the tech giants stock prices plummet, we're going to continue to do that just because of the sheer volume of cases we needed for efficiency.
And let me just add this. Let's say something disappears. I don't think it will. I think we're going to keep emerging. But the point is, as lawyers, we need to be part of the design, the development, the deployment of AI tools that work for us. We should not leave that to technologists, which is why we're all here today, so that we can be educated enough to be active, give feedback to the Axons and other vendors so that they are creating something that actually works to make our jobs easier.
I would second that, because when you look at what Alondra Nelson was trying to do with the blueprint from AI, all these things were supposed to be coming from the bottom up, right? You're supposed to, in the prisms that she put out, and it was what we put as the title of our cause, is aligning these AI tools with social and democratic values. And, the fact is we were lucky that there wasn't an order, which is what the president tried to do, to have no regulation of artificial intelligence by the states. Thank you. It was actually Nashville that stopped it because of the fear that they would steal all the intellectual property from singer-songwriters. Senator Blackburn stopped it. But there should be so much more regulation and so much more experiments done on how we can actually use this technology safely. I mean, I'm much less concerned about the stock market and the AI bubble than I'm concerned with this latest thing that came from where they're saying, well, we may have developed a software that can destroy the infrastructure of every system because they can go right to, all the hidden problems in the software. You saw that. It was just, it was in yesterday's news. I mean, I think these companies know that this is so potentially dangerous, it can destroy the planet. Let's be honest. So I'm more concerned about that.
I, for one, welcome our AI overlords and are ready to do whatever they want, for the record.
So I want to turn to this question because it's such a good one that I frankly wish I had asked. So you have Westlaw or LexisNexis AI tools that you're confident in. How do you build practice and policy to constrain the use of staff of other public or general purpose AI tools that may not be trustworthy, or at least that haven't been reviewed and approved? I think Dave Mulroy touched upon this a little bit about how oversight always requires certain kinds of training, but are there other ways that you can ensure that there's not, especially as younger attorneys and younger folks come in with so accustomed to using AI in every part of their lives, how do you make sure they're not using it irresponsibly?
And I'm going to jump in on this real quick and have that be my concluding comment, because as you said, I did need to leave it a little bit early. I'm not going to try to stop all my staff from ever using ChatGPT or Claude for their own purposes, like even during business hours, if they want to check on something and do sort of some quick research. But the rule, I think, that is understood in our office is that if you are using any kind of AI that is going to be sent out to an external party, then it has to be rigorously checked for material accuracy and signed off by that person. And if we find out that that didn't happen, then there will be consequences. And I just trust my staff to be responsible. And maybe there are other things I should be doing, but that's all I'm doing right now. But I'm going to let other people maybe who have thought about it longer speak. And I just want to say thank you very much for the opportunities. It's been very good.
Thanks so much, Dia, for joining us. And we have a few more minutes for the rest of folks, I hope. We'll end right at the 30-minute mark.
And I think it's a wonderful example that D.A. Mulroy has set really a lawyer human-centered use of technology, where lawyers, we are the leaders and the AI is our thought partner that we supervise. I think that mentality is extremely important. And I think whatever your tool, Litify, NICE, Axon, there's CoCounsel, Clear, there's lots of tools, but it still needs to be harnessed in our judgment as attorneys.
Thanks, Allison. We just lost the DA, but we'll see if other folks can jump in on this question that I should have gotten to before he left. How are DAs, presumably, or prosecutors ensuring that AI acquired information or answers are being produced when they're Brady material? The example of screening phone calls for evidence that would support a not guilty by reason of mental defect would present this issue if the AI product did find such evidence. Is that something you've encountered, PD Martinez, at all, or?
Not yet, but I'm putting it on my list.
There's some really thoughtful questions here.
That's a really good question.
Thank you for the question.
It's so interesting too, because in this course we taught, we had all the students put in chats to any AI tool they wanted and save the answers. And it was very telling because, and I saw Allison nodding her head at one point when I was talking about misgrounded information. It doesn't answer the question that you're asking, or it starts giving you the same answers again and again repetitively. These are the kinds of things that the Stanford scientists found, are, very serious problems. And I just don't think enough investigation has been done, really good empirical work on these problems, because it has been unregulated. And we have to get facial recognition regulated. That is absolutely essential. And we have to get genetic genealogy regulated. I didn't even get a chance to talk about that. I do have one thing I'd like to share with, assuming there's lots of district attorneys watching this. Recently, a cold case was solved in Travis County, Texas, by a cold case police officer named Dan Jackson, with the assistance of Jose Garza, who's the district attorney in Travis County, and also my friend Steve Kramer, who is somebody that was the FBI's genetic genealogist, and now he has his own operation. He found the Golden State Killer and others. This was an extraordinary effort that involved lots of law enforcement entities. And it actually found that this horrible murder that had haunted Austin for decades, called the Yogurt Shop murders, where 4 young women were found naked, tied up. Their hands were tied behind their backs with their own brassieres, and then shot in the back of the head. A false confession was, 3 false confessions were produced. One of the principals there was a detective named Hector Polanco, who actually produced a false confession of one of our first Innocence Project cases involving the death penalty, that of Chris Ochoa. So I was always paying careful attention to this. But when they finally did the investigation, they went out to they actually used some the Nibbin system, where you look at the tool marks on bullets, and were able to find a gun that belonged to this particular individual named Richard Brasher. And then they made an inquiry about a case in South Carolina, and the person in South Carolina suddenly said, "Oh, by the way, in our case, the person involved had taken the victims and tied their hands with their own underclothes, right, and then shot them." And then finally, they were able to find this Richard Brasher had been picked up for a traffic offense just outside of Austin, right? And they were able to get the gun that he was holding. And that gun was linked to all the other crimes, as well as doing some Y DNA testing. This is amazing. I mean, I can't begin to tell you how many cases could be solved. There are 80,000 cases every year where CODIS will identify a DNA profile from relevant, probative crime scene evidence that does not match another open case and does not match any individual in the system. 80,000 a year. But more importantly, over the last few decades, we have 20 million cases like this in the system. And many of us believe this guy, Richard Brasher, obviously was a serial murderer. We have somebody that just pled guilty here in Long Island, Richard Ewerman, to at least 8. I am absolutely certain we are going to find others that were people that were in prison for Ewerman crimes. That's happened in many other jurisdictions with serial murderers. But we have, if we begin to pull this together, I think that an alliance of cold case detectives and what we call conviction integrity units doing these reinvestigations, particularly with genetic genealogy, because now you can take DNA from the shaft of a hair and do some genetic genealogy and other kinds of research. That must be regulated, by the way. This all must be regulated. We're now dealing with what they call single nucleotide polymorphisms. This is not your STR DNA profile. The SNPs are everything about you, all your private medical information. So the American Bar Association unanimously approved the model bill that we got passed in Maryland. This should be passed in every state. Every district attorney on this call should want that bill passed.
Thank you. The last question, I know I said we'd end it, but we're going to go a minute or two over. If these AI tools make prosecution more efficient, are we comfortable with the risk that they increase incarceration, or what specific processes are we building to ensure that they instead increase diversion and I assume other approaches to reducing incarceration? How will we know which one is happening? Anyone want to take that?
I'll start and then I'm sure everyone will give their input. I think that's a really important question. And it's asking, how do we make sure it's safe? Where is the governance? And the answer is there's not much out there. And that's where we have to start creating the governance ourselves. Start with the report. The Council on Criminal Justice is a good framework. But it's our obligation to make sure that it's safe. And as prosecutors, especially, I'm a former prosecutor, so we have that obligation and we have to do it. There's nothing out there that really is in existence. We have to create it, is what I'm suggesting. And the second thing I would say is when we think about AI, think about how you can use it in your office for other things. If you want to research conviction integrity units, if you want to look at your charging practices, who gets into diversion, you can use it for digital evidence, but be open about how it can be used. And think about AI in this way, and then I'll close. AI has tremendous benefits, but the risks are right there. They're intertwined, and you have to think of both simultaneously, the benefits and the risks, in a human-centered, lawyerly way. And if you have that mentality, then you are an AI-driven leader, and that's what we want.
Anyone else want to say closing thoughts? And I'm sorry that we didn't get to all the questions. There were so many good ones, and clearly there's a need for more conversation about this, and we'll continue to address that need as best we can.
Well, I'm less concerned about suddenly these AI tools are going to flood the jails with new people. I think it's most important that each of these tools is used to make sure we do justice and we get accountability and we get the right people, because there is so much error in this system, right? I mean, I don't know. We've had, over 3,000 wrongful convictions that we've documented in the Registry of Exonerations since 1989, but there's so many more. And what about people that shouldn't be charged in the first place by anybody's calculation? We've got a lot of work to get all the people that are in a mass incarceration position now in the United States. We're working on it, but got a lot of work left to do there. Even of people that are serving more time than they should be by any reasonable calculation, with 3-strike statutes and other things of this kind. But AI is not the problem. The problem is how much are we willing to do politically to regulate these tools? Billionaires are controlling this incredible technology, right? They are not playing, they're not saying, oh, we want to come to you and give you all of this material because we're sure you can do great things with it. They did not opt for aligning these tools with social and democratic values. Quite the contrary. The current orientation of this administration is we should have hegemony over these tools and make as much money as we can and beat China. This is not a good orientation, right? And it's going to have to be people in the criminal legal system that care about accountability and justice, that start passing statutes on facial recognition, on genetic genealogy, on proper standards for using these tools, because they're full of error. They are. I mean, so that's my take on it.
Well, thank you all so much for joining. Again, I apologize we couldn't get to all of the questions. We had such a good turnout for this, and so clearly there's a great interest in the IIP, and John Jay's Future of Public Safety initiative will continue to address these issues. I really want to thank our incredible panelists today, D.A. Mulroy, who left us, Barry Scheck, P.D. Martinez, and Allison Pierre. We are so honored to have your brilliance and insight and leadership with us today. Thank you all. We will be sending out updates, including all links to the many, many things that were mentioned today. And we really thank you for watching. And please sign up at prosecution.org if you haven't already, to make sure you're kept apprised of all of our future webinars. Thank you so much and have a wonderful weekend.
Thank you, you too.
Thank you.
Thank
Take
you.
care.